teach it from two different perspectives: the owner of a sports franchise or a sports venue, which is the course you were taking, and then the one that I just finished today, representing a professional athlete or the counterparty to the professional athlete in an endorsement agreement, in a product endorsement or publicity rights agreement. So let's take those one at a time. For the owner of a sports franchise or a sports venue, right, you want to be able, with your counterparties in your major transactions, that being the lease agreement, the naming rights agreement, the presenting sponsorship, the major food and beverage agreements. In representing the owner, you certainly want to be able to resolve any alleged breaches, really from either side, in a quick and expeditious and business-like fashion. Owners of sports venues and those who engage as counterparties in leases and naming rights, as you know, these are long-term relationships. These are like marriages. You don't divorce easily. So how do you prevent somebody running to court and filing for injunctive relief, which is a disaster for the owner of a venue, obviously? Well, you require mediation. You require business-to-business attempted resolution first. And really the same applies with representing the professional athlete as well. Business to business, Nike and Peyton Manning, Nike and Derek Jeter, whoever it might be. If there's a dispute, you want the business people, not the lawyers, to resolve that as quickly and efficiently, and perhaps even amend the agreements, accordingly to fit the then purposes of the agreement, which may have changed over the long life of the contract. Oftentimes that's the case, and then you do an amendment. As you know from the course, the lease agreements that I've worked on, 7, 8 amendments. Well, each and every one of those could have been lawsuits, but instead there's a business-to-business resolution, and you document it and you amend the lease to fit the current situation. That comes out of mediation. Then when mediation fails to resolve it on a business-to-business basis, the reason I counsel arbitration in both of these contexts, and by that I mean final binding arbitration and confidential, is it's faster, it's more efficient, you can set all the rules, you can set all the timetables, and you can know, so now we're past the business to business, you can know that these counterparties have agreed within 3 to 6 months we will be done with this. And it's not going to drag on for years and years.
Right.
Yes, the follow-on, the corollary to what I have just said is you live in a public environment. You live in a reputational world. And that's why any time a dispute escapes to a court system, it's out of your control. You can no longer control the spin that the press might put on it, whether it be, again, going back to a superstar athlete, which is what I'm teaching now. The dispute spins out of control. There's a terrible Lance Armstrong kind of case, and I'm not defending Armstrong, but you see just litigation on top of litigation. Instead of, and he did try to have a final binding arbitration confidentially, but it just didn't hold up. And then coming over to the other side, yes, they're long-term marital relationships, if you will, and I think the big difference on the ownership side, and now I'm going back to the owner of the sports venue, is he or she wants to be able to not impact negatively the reputation of the franchise. And if there's a public airing of grievances, that can damage the franchise brand, which is forever. So the governing bodies, when you start talking about WADA, the World, the doping associations, the Olympic associations, qualifications for FIFA or whoever it might be, and you have a player dispute because really you don't have the union mentality. The players really aren't meaningfully represented by unions. So where do they go? Instead of Commissioner Roger Goodell in the case of Deflategate, if you're familiar with that, you go to the Court of Arbitration for Sport for resolving the individual player grievance and or whether it be doping or whatever the grievance might be. And that's, of course, public, and that's, of course, pre-approved arbitrators. And I think it mimics and mirrors, the arbitration system over in America's 3 major leagues in many respects. But those are league intra-governing body disputes. And what we're talking about here is commercial disputes.
Right.
That's what distinguishes.
Yeah.
It's the same as you would if you're a superstar athlete. You've transcended success on the field. You have branding mechanisms all outside your successes. I'm thinking of an Arnold Palmer or a LeBron James, with whom we've worked back home over the years on and off. But anyways, you look for, now we have a dispute. Now it's going to arbitration. You have somebody, and you get somebody to represent, and I did many of these when I was at IMG, who has been around this area and it knows it and has been immersed in it for many years, so that, because most of these arbitrations should settle.
Right.
So even once you pass, so you need someone who's been experienced enough to know what are the parameters for a win-win success within the arbitration before you let the arbitrator make the decision. That's what I would recommend. Somebody who knows the area well enough to say during the arbitration, this is a fair settlement. Let's just leave it alone. Expert knows. It almost gets down to data analytics, to be quite honest. In the industry, those disputes that have gone the distance, unfortunately, that have resulted in a public display. So you have algorithms, you're running spreadsheets, you're doing that sort of thing to say, here's the likely outcome if you let this go to arbitration. And many of the arbitrators, as we talk about, sometimes it's a 3-person panel, or you pick one, they pick one, and they pick the third. They have track records. So you do, and the experienced person, the person you want representing the superstar celebrity, is somebody who has all that data in front of him or her to say, here's the probability of success, here's the likelihood of the outcome. Look, if you can satisfy the many prerequisites for temporary TRO, temporary restraining order, or then get past that to preliminary injunctive relief. And we all know irreparable harm, can't be quantified, damage can't be quantified. All the things we learn in our civil procedure class that are required for emergency and then injunctive relief. And there are those situations. So the way I teach that course is to have a carve out for emergency or injunctive relief when appropriate. And generally, the federal court, let's stay at the federal court, because state courts can be idiosyncratic, and they may say, this is an interesting case, and they would like to see all of it, or an interesting dispute. Generally speaking, it goes all the way to the Supreme Court, there's great deference to an agreement to arbitrate a dispute, great deference. And for the most part, they will defer to the final binding arbitration clause. And in fact, I've seen it the other way, where they'll say, almost flip it around and say, well, no, you haven't satisfied these very steep requirements for emergency relief, so they'll send the whole thing back. That's more my experience.
Okay.
Yeah, it goes full circle to where we started. So I've been in a number of confidential final binding arbitrations with, let's just say superstar celebrity athlete types. And we've done all the data, and we've done all the algorithms, and we know the likelihood of the outcome. And almost always I was on, as general counsel for IMG, I was counseling the talent, so to speak. And you could see which way, we'd almost just agree on one arbitrator, just to make it easier, simpler, and quicker, rather than 3. And you could see the arbitrator doing shuttle diplomacy. This happened more than once. And you knew the arbitrator because there's only so many that would do these kinds of cases that parties would allow. And both times, the same thing happened. We counseled almost to go back a step to mediation. We would say to the talent, as I call it, look, and he or she, I'll make it neutral, wasn't accepting our algorithmic settlement recommendation. We'd say, You have a long-standing business relationship with Nike, Under Armour, whoever was the titleist. We're going to get permission of the arbitrator to suspend the arbitration. You go have a business-to-business meeting because you're going to want to do business with these people again, or in the industry again. And you know, it's much better to switch than to fight to a conclusion that neither side's going to be very happy with, because you could tell the arbitrator was going to be a stern final. You could just sense it. And in both cases, I'm happy to say, they repaired that relationship. It basically resulted in a renewal, or at least an extension, or modification, or a termination. You know, and so I just keep coming back to, with all these years of experience, business people do better than lawyers in resolving these disputes. Again, staying with those same kinds of examples. I liked keeping mediation alive once arbitration. So you can only go so long in mediation and say, okay, well, we're not going to resolve this. Now we'll start the arbitration over here. But we'll allow you to mediate, which is kind of what I just described in those situations. Now, I like staying with the same person.
Right.
Why? Because the person knows the case. Now it's over here where he has or she has authority to decide it. But throughout, the longer you're in this process, and still we're going to say it's only 6 months, let's say 3 months here, 3 months there, that person she gets a sense of what it will take to make this, and then the shuttle diplomacy thing starts happening. And that's when you're over here in arbitration. It's what I just described. The arbitrator can say, well, let's go back to a business-to-business mediation. That's permissible under the rules that we've agreed. And then that same person solves the case and says it's been mediated to conclusion, rather than my having to issue a final order.